Excuse me. Excuse me. They're coming to the court.
Yes, coming. Coming. Yes, but abasajja baagala osalira Eron without lawyers. No. No, let the lawyers come in. At least a lawyer. At least a lawyer. Plus the MP. Okay, that's saying that. One. The prison officer, police officer, that court is a public place.
Somebody said they had to call the council now. No. It's rising over. It's rising over.
Wetwogera nga tulindako okulaba nga kooti eggulwawo kuba tutegeddeko nti oluvannyuma lw'okuba nti Eron Kiiza abadde aleetebwa Registrar agambye omulamuzi kati Eron bw'aba nga atuusiddwa ku kooti onaaweereza otya ruling email nga omusibe ali wano so twakitegeeza olina okusaba omusibe olina okumusomera ruling ye kubanga ali wano mu maaso go so bw'atyo omulamuzi n'avaayo gy'abadde oba nkuyite kwekukuma kuba tabadde mu kyembaazi ze abadde sayidi ya Registrar so gy'afulumye okukomawo wano mu kyembaazi ze sika tulina tulabe obanga defiance y'abannamateeka n'abooluganda n'ab'emikwano ejja kukola so okulaba nga oba oliawo ateekebwa mu open court naye nga mu kusooka bannamateeka bategeezebwa nti ono tagenda kubanga afuna ruling ye mu hard copy instead ebadde yakuba ngeri ya email naye kati bwetwogera atusibwa ku kooti wano era nga tumulabyeko so tugira tulabe kiki ekiddako naye nga wetulifu okulaba bwetusaako byonna nga buli yembeera bwetyo bwekyali wano era nga tukyagezaako okulaba ngaoliawo tubatuusaako nga bwetutambula. Yeah, defiance has paid off. Bannamateeka badde bagambye tebava wano okutuusa nga munnaabwe bamulabyeko era okutuusa nga ruling bagifunye. Omulamuzi abadde yeekumye mu kyemba za registra naye oluvannyuma lw'okuba nti Eron Kiiza abadde atuusiddwa bannamateeka registra ategezezza omulamuzi ono Singiza Douglas tasobola kuwa ruling ku email nga omuwaabi oba kasera kano omusibe alyeruzira Eron Kiiza nga waali so nolwekityo n'avaayo mu ofiisi ya registra yabadde yakukumye n'ajja ano era nga tulinda kulaba oba bagulawo kooti then ensonga tutandika okulaba engeri gye zitambulamu naye nga Eron Kiiza waali alabiddwako era nga akyali mu holding cell naba prisons wano ku high court mu Kampala twetabazi so wetuli okusobola okulaba nga tubatuusaako embeera ziri bwemera bweri kaseera kano. Omwefubi okutwegattako kutegeeza nti council Eron Kiiza yatuusiddwa dda era nga tulinda kulaba kooti eno eggulwawo then tulabe engeri ensonga bwe zitambula.
They stopped anyone from going past that door.
Sorry?
Have they stopped people from going
Yeah.
past that door?
Omulwadde waffe omulungi tukwebaza naye n'okubanga okyayinaffe era nga okyagoberera tulina okulaba obanga baggulawo kooti then ensonga oba eweebwe naye ekisobola n'omulyango ogenda mu chambers oba alukuubo teri mukakkirizibwa kubanga ayitamu ndaba ofisi atone general kanso walubiri kuta banamateeka bakulira kanso George Musisi kanso Eron Kiiza era nga y'omu ku bannamateeka ba Eron Kiiza nebayo kakayire bagamba nti beetegefu ruling bweraabezze oba ebisaidi yaabwe okusaidi yaabwe kubanga bagamba ebisaidi yaabwe oba beetegefu okuba mu filing endala oba okukola appeals era nga bagamba nti in application ezenjawulo wano Mukono division so ebyokubanga nenyako so babanga oba naye nga bannamateeka akugambye nti oba enjiri ya kanokisa besi ya defiance egenze eyingira buli bamu nti oluvannyuma okuba nti bagambirwa nti bagenda kufuna muhadiko wabula eyinza okuba ya email bagambye nti bavaawo bafunye ruling eyo era kubadde guli gutyo Eron Kiiza n'aleetebwa ekiwaliza omulamuzi Douglas Kiiza okuvaayo gy'abadde yeekukumye mu ofiisi ya registra ajje mu kyembaazi ze era kati nga waali wano akigalidde mu kyembaazi ze naye nga nabano abagulawo kooti balina orders ze wabiragiro bye ebikkiriza abantu ba bulijjo okuakisesinga fula eyokuna ekizimbe kya Acoli Towers Kampala omulamuzi Douglas Kiiza akkiriza ba bulijjo bagoberera ensalawo si bwekyo embeera bwekyali embeera ya bukakkamu obutafaanako na mulundi guli ewaali security y'amaanyi bano bakakamu era batabasinga bannamateeka babayita mikwano gya Eron Kiiza oteeka n'abamu ku baclients be kitegeddeko nti abamu ku baclients be bazze okwingira naye solidarity nga ageza kulwanira okufuna so bwekyo bwe tuli so okulaba nga obaolyawo tulaba gye binabeera naye bakigamba nti tunaluwulira ebiseera ebisinga tutera kubyukira naye ffe babisaze kuzigudire tetulinze kubuuza nti ezinga bwolwange ebiseera ebisinga atera kutwalira musiba emmere so bwekyo bwe tuli wano nze bukose so okulaba nga mbawa updates oba okubagezaako nga bwe bigenda omaaso nkulu eye civil division oba ewozesa emisango egimugazi ekitali gya naggomola so wetuli era ku floor eyokuna wali courtroom eri courtroom naye nga room 1 of first floor naye nga room 16 kooti eri kooti 1 naye nga bizimbe eri room 16 so wekityo embeera okiriza sokulaba nga oba oliawo balaba ye kanso Benjamin Katana wa National Platform mukwano gwa Eron Kiiza naye ali wano nnyo sokulaba nga oba oliawo alaba abigenda maaso mu ggwanga kutegeeza nti wasinga okuba bannamateeka mikwano gye oteeka ne baclients abamu bazze maybe ne bannamawulire bagezaako bo bangiko sokulaba nga nabo bagoberera n'okwagezaako ensonga zino nga bwe ziri okuba mu gy'amawulire online empapula eza radio tv so bonna bali wano sokulaba ye kanso ye honorable Isaac Pacific ye agumbidde ddala wano eyeenyeenya tavaawo yagamba nti ketonyera gwake alina okuva wano ng'ategedde mukwano gwe ate n'amateeka feeti yeebwere so maani nnyo era nga teyeenyeenya kizibu okuva awo talinavaawo noba nga abagulawoko nayagala apipingeyo oba alingizeyoko alabe kiki ekigenda mu maaso bagezaako okulaba defiantly bagezaako okwakisesinga basokita bannamateeka kitegeeza bandegenda mu
Just take him just like that. Yeah, because of very
kale abalabi bange abalungi mberekereza ebyokubaddira nafunye updates ngala ezisembaku ezo olwokutegeera tewannabaawo kirala kyonna kijja okutegeezebwa bannamateeka badde bagezaako okumugoberera naye bategeeza nti atemukutamuti agenze kwetawuluzaamuko akoma babadde balowooza nti oba oli abamukusa bamutwala chambers naye nga bannamateeka bafudisimu nabategeeza nti ageza okufula eyokutaano so nga bwabunanyisire bya bannamateeka bagezaako kubanga badduka bamukukusa bamufula eyokutaano babadde bamukusa nga tebategedde nti akukusibwa paka okufula eyokutaano so buuno era nga gino emisana gyolaba gyabannamateeka nabokusobola bantu bakisesinga okubanga bamulabako babadde bamukusizaako nga tebategedde naye nga twogera okufula eyokutaano era nga tubadde tulungumanidde okufula eyokuna ne bagezaako okumukukusa okumeta mukufula eyokutaano ne bababugulizaako ekintu kyali awo mandibanga mukuma lubugo nga temukyali waliwo so kanasala naffe yugayo namukwamisa kufula eyokutaano oyo amateeka ga Eron Kiiza okwangaija
This side is mine alone. I don't want to go on my side. You may keep your keep. My father, you can come.
ye kanso Eron Kiiza n'atuusibwa kkooti okulaba nga afuna aluliriye kanso. Kanso Eron Kiiza omulaba akozeemuko naye nga waali nnyo okusooka nga afuna ensawo y'omulamuzi lunaku lwa leero, naye nga bannamateeka bagamba nti beetegefu oba eri ku sayidi yaabwe te ku sayidi yaabwe bo beetegefu okulwanira eddembe lye osobola okulaba ng'afuna obwenkanya nga bw'abwagala era nga bw'abumaanira, nga bagamba nti oluvannyuma lwa kkooti ensukkulumu okugamba nti kkooti y'amagye yaliwo omugenyi w'amateeka, bagamba nti kkooti eriwo omugenyi w'amateeka tasobola kusalira muntu musango ng'ate yo teriwo mateeka, so nga bagamba nti omuntu omufu tasobola kusalira mulamu musango, so nga bwegrawundi tebatudde osobola okulaba nga oba oli awo bali wano osobola okulaba nga bafuna ensawo y'omulamuzi. Naye omulamuzi y'omu application yeefaananyiza ng'eno akawungezi k'eggulo yagigobye eyabadde ya account officer Kiiza ne munne Hajji Obed Lutale babadde bagezaako okufuna obwenkanya era nga bagamba nabo bali eruzira mu bukyamu. Omulamuzi kyagambye nti si kituufu kubanga yakizudde nti waliwo emisango emirala egyabaguddwako mu kkooti enakawa, n'olwekyo bo eruzira baliyo mu butuufu olw'okuba nti waliwo emisango empya egyabaguddwako. Naye ate yo ye Eron kyayawula mu kkooti kubanga ye yasalira kkooti y'amagye ate kkooti ensukkulumu gye yagamba nti teriiwo mu butuufu bwayo. So katuuni tulabe bo omulamuzi ono y'omu kikyasalawo olunaku lwa leero ku nsonga eno. Awo abamu ku basirikale abamulabiriza era nga sipiriti ya prison yo eri gguluggulu wabweru y'omunda.
No, for them. That makes sense.
That's how we get but the material here now, I don't want the entire WhatsApp group.
Kati tulina mulamuzi abe ng'ayingira, so yo kkooti yatudde dda. Mugaye. Akatwegattako tuli wano tulinda nsawo ya mulamuzi Douglas Kiiza era nga kkooti yo etudde osobola okulaba nga bafuna council Eron Kiiza afuna ruling. Mu kusooka babadde tebagala kugibawa, bagamba tajja kugibawa ng'ayita ku email kuba abuuza bannamateeka abaakeddewo kiki ekyabadde kibaleese ne bamutegeeza nti bakimye ruling. N'abuuza nti byabadde awalumu y'abeesigye yabayise. So defiantly bannamateeka ne bagamba tujja kuvaawo nga tufunye ruling. Oba ogiweza ku email naye twaga email nga tuli wano. Naye ate oluvannyuma ennyo kitegeezeddwako nti Eron Kiiza abadde ali mu kkubo era bw'atuuse omulamuzi Singiza kigambibwa nti abadde yeekwese mu office ya registrar, naye Eron Kiiza bw'atuuse registrar n'amugamba omanyi genda mu kkooti kubanga omusibe waba atuuse aba alina okufuna ruling ye. Bwe butyo defiantly bannamateeka oluvannyuma okulemerako kakkana nga omulamuzi akkiriza agende mu open court kyokubanga awa ruling as opposed ku email gy'abadde aproposed mu kusooka. So tuli wano tumulinda tulabe obanga ajja awa ruling eyo oba naye nga bannamateeka bagamba nti yonna ne ruling yenaabezze website yaabwe oba tekusayidi yaabwe bo beetegefu era nga tebakina kinabakizeeko kivudde mu ruling eyo bajja kyambala nga bwe kinaaba kizze. Naye nga ye Eron Kiiza awakanya okuba nti yasalirwa era nga asaavinga sentence mu kkooti etaliiwo oluvannyuma lwa kkooti ensukkulumu okugamba nti eno kkooti y'amagye terina buyinza buwozesa misango nga convictinga muntu nga Eron Kiiza. So Eron Kiiza agamba nti ekibanga kkooti enfufu ate lwaki mbeera mu kkomera oluvannyuma lw'okuba nti eno kkooti yo akufu. Omulamuzi yagamba nti oyo yenna eyajulira ng'awakanya ensalawo ya kkooti y'amagye wadde okugenda mu kkooti eza bulijjo okusaba remedies oba okusaba kugondezebwamu n'okuyimbulwa. So Eron kuno kwe yasinziira n'ajja mu kkooti eno okusobola okulaba nga oboolyawo ayagala kufuna eddembe lye naye ali obutaala nga nsingo ya nkoko. So bwe tutyo bwe tuli okusobola okulaba nga oboolyawo tugoberera n'okulaba ki ebinaaba ebivudde mu kusalawo kw'omulamuzi. Tetumanyi lwaki omulamuzi akyaluddeyo okuvaayo naye nga bo bannamateeka ab'emikwano n'abamu ku batalambisibwa Eron Kiiza bwe bali nnyo okusobola okulaba nga oboolyawo bafuna ruling yonna nga bwe naaba ezze. So tubeebaza gwe wena wenna akyalemeddeko tukusaamu ekitiibwa n'okukaddatako k'otuteekamu. Weebale nnyo weebale ddala okubanga otuwadde obudde ne kaddatako okusobola okulaba nga ogoberera embeera nga bubeere. Nze mukose Arnold Anthony tuli butereevu ku Alternative Uganda Facebook page, TikTok TV Facebook page ne Alternative Uganda YouTube. So ogenda ku website yaffe ku www.alternativeuganda.org nakosa okuba nga ofuna empeereza ez'enjawulo www.alternativeuganda.org so okufuna empeereza zaffe ez'enjawulo. Oba osobola okukyalirako ku ofiisi zaffe awo Acoli Nanganda bw'oba ova sayidi z'e Makindye nga wakayisa ofiisi ya NIRA ey'e Makindye era nga twashifutinzeemu okuva otubadde meters 5 okutuuka wano awala tuli ku 15C ku Setenda Lane ojja kubanga otulaba 15C ku Setenda Lane ojja kubanga otulaba location eno mpya mita ziri nga 5 okuba otubadde awakadde so tekijja kalubiriza nnyo just nga wakayisa katono nnyo ku ofiisi ya NIRA obadde ova Makindye otubadde obadde osooka wafuna okudda ku ofiisi ya NIRA naye kati otazze osooka ofiisi ya NIRA n'olyoka ewaffe kubanga ova sayidi za Makindye naye nga ku mukono gwe gumu ogwo oluguudo olulwe Makindye oludda Buziga Munyonyo. So ojja kubanga nawo otufuna obulungi nnyo nnyini ddala tuli awo Acoli Nanganda so okujja ku ofiisi yaffe musobola okulaba nga ofuna empeereza zaffe oba n'okwebuuzaako mu mbeera ez'enjawulo. So tuweeza message ku soogera mu inbox ya pages ezo ez'enjawulo ojja kubanga osobola okuba nga ofuna oba nsobola n'okutubirako ku ssimu 0784 okay first of all ya Airtel 07029776 ojja kubanga ofuna obulungi nnyo nnyini ddala naye nga tukyagenda maaso yagendako omulamuzi okulaba nga ajja omulamuzi Douglas Kiiza naye nga yo kkooti yatudde dda okubanga efuna ensalawo ey'omusango gwawabirwa Eron Kiiza nga yeekubira enduulu nga awakanya okuba nti aholdingibwa oba asibibwa ekitali mu bumenyi bw'amateeka oluvannyuma lwa kkooti ensukulumu kulagira nti ono gyali aliyo mu bumenyi bw'amateeka. Ekyenjawulo tuyinza obutakwatibwa nkyamulamuzi ono kubanga muli yatugamba yagala kifaananyi kye kubanga kirabika ku mitimbagano. So naye nga eddoboozi tuyinza okuba nga eddoboozi tulifuna naye nga kyo kifaananyi tuyinza obutagifuna kubanga ye ebiseera ebisinga tayagala nnyo okulabikira ku mitimbagano oba ku mikutu gy'amawulire okuggyako ng'obayo anaaba akikkiriza naye omulundi ogwasembayo nga tugaanibwa okulaga ekifaananyi kye naye nga tuliwantulinga buno atuusa.
This is business code number 33 of 2025.
Yes. Like I requested last time, please, and I do this for the security of the presiding judge.
This is business code number 33 of 2025. Uganda Law Society as the Secretary of Prison and the Attorney General. Hello there.
Maybe that one's what. It says ignore it.
We ignore these ones.
Yes.
My Lord, if it pleases court, Peter Muchiti Warupiri. I am appearing with my land friends George Musisi, Kunihira Proscovia, Katoto Musime, Kenneth Muhanji, Benjamin Katana, Suleiman Kakaire, and Tobias Kafuswa Edwin for the applicant.
And my learned friend Nakwera Johnson appears for the respondent.
The record is being captured. Hence.
All of these matters have been reserved for, I think, a ruling. We're ready to see what's ruling.
Okay. Before we come to the ruling, because I just wanted to confirm whether all the directions were complied with as given last time. I think we start from there. Maybe you can address us on that.
My lord, the directive was to serve all applications on the Attorney General.
Yes.
The last time we were in court that day.
Yes.
We did the service. For the applications that the Attorney General had not filed the affidavits in reply, he was to file latest the following day, and all parties were then supposed to file submissions. We did comply for the applicants. I've not seen some of the submissions from Attorney General in some of the applications.
Okay.
But the timelines were fixed.
Good thing he's here. He will address us. AG, what did you do since last time?
Johnson Atwere is my name. For record. Your Lordship, you gave directions, and you indicated that the directions you gave, and you were in response to my clarification, that they concerned to the applications that had been filed and served on us. And it was only number 33 of 2025 at that time that had been served on Attorney General. And you gave directive that by close of that day, we should have filed a reply, an affidavit in reply, and the following day, all parties should have submitted submissions.
That is 33.
33. The following day, we complied with the orders of court, and we filed our affidavit in reply and submissions for number 33. The following day, we checked on ECMIS. The only documents we could find were only affidavits for number 37 and others which had not been served on us. We could not reply to affidavits because we didn't know, they did not contain the notes of motion. Yesterday, we got number 37, and we did a reply. Today morning, we filed the same on ECMIS in response to number 37 of 2025. The rest we have not, because they have not been served on us. One common denominator, my lord, is that they look similar, and the orders they are seeking are the same for number 33 and number 37. I don't think they would even need, as you had guided before, that you would look at whether you can or you may not consolidate them. But I think, in my opinion, is that the remedy is the same. There's no need even to give it any other date. And our submissions would be adopted for the same. Thank you, my lord.
So that explains why, as a judge, I was still not sure what was And that's why I had initially dodged you, because I could see in the system that the directions have not been fully complied. So we agreed now, all the pleadings and arguments are in.
Yes, ma'am.
Okay, I think we are good to go. For me, it is always better not to rush a ruling like this. So if you give me at least 4 days, I should be able to come out with a decision. So tentatively, that makes it well, Michael. Wait, I'm coming. Okay, Monday. Okay, maybe let me first. Yeah, third. Okay, let me first ask Mr. Walubidi. Supposing we assume that what was argued and pleaded in 33 covers 37 or any other related application. Can you, because I've looked at your submission, you talk about 2 main issues. You could address this court on only the first issue, then so that I can understand your mind better. I don't want to second guess your key argument on issue number 1. I know you can do it better. All the facts are known to us. We have read and understood them. So what argument are you making?
The basic argument, my lord, we're making is that the applicant, counsel Eron Kiiza, was subjected to contempt proceedings before a court which the Supreme Court has found to have no competence and jurisdiction. Given its composition, its mode of appointment, and the many other reasons that the Supreme Court determined. The Supreme Court then held that where proceedings before the General Court Martial have been challenged, the decision of the Supreme Court nullifying the proceedings before the court martial would have retrospective effect.
Last time, I appealed to lawyers to break it down so that people can understand what we are doing. It could be an easy English word for you. For
yes,
all
I will read from the decree of the Supreme Court.
Okay, but you can simplify us.
Yes, I will. In the second order of the Supreme Court, the court held that all charges, ongoing criminal trials, or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. That meant that anything going on in the court martial involving civilians would have to terminate in the court martial. And possibly, if it was possible, transfer it to civilian courts.
So, just briefly, realistically, which court do you think at that point the Supreme Court probably had in mind? A civil court or a criminal court?
If there were criminal trials, then they would go to the criminal court. But my lord, the point I want to point out is that in practice, there would be no transfer. We've had the most recent experience involving Dr. Besige and Ajurutare. What has happened to them is public knowledge. And I think, my lord, you have taken judicial notice of it, is that they have been charged afresh because it's not possible to transfer. You will have to, if there is some evidence that the DPP considers worth of a charge, to start de novo, as has been done in the case of Dr. Besige, his or her choose. Now, my lord, the most critical and applicable aspect, Counsel Eron Kiiza, is order number 3 of the Supreme Court. And I will read it. It's a short one. It says, this judgment shall have no retrospective effect on any convictions made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law.
Okay, and that's where I wanted you to help us. Because that order seems to have 2 legs, so to speak. Yes. So the first one is, what do you think, in your view, the Supreme Court meant when they said no retrospective effect? We can start it from there to break it down for the media and therefore members of the public.
Not having a retrospective effect means that convictions and sentences that had been imposed by court martials on civilians would stand, they would not be nullified. That's the first thing.
Okay.
However, that's why they use the
what say. Yes. However, where those convictions and sentences were being challenged, then the judgment would have the retrospective effect of nullifying what the court martial had done.
Okay. You know, last time I told people you are my former teacher, and I'm happy with that. So I don't want to say please stop there, but I can request you to hold on a little bit, and I can share this experience. When I was a chief magistrate, I would deal with the applications for revision, where an LC1 court had convicted people, you know, on offenses of defilement. They would have a judgment. So whenever those decisions would come to me, just one paragraph, I would say no jurisdiction, cancelled. I wouldn't go into all those details. Now, in the same way, why I'm raising that question using that example is this civil court the right court in terms of order number 3 of the Supreme Court to give the correct reliefs? Wouldn't it be possible that probably a criminal division judge would look at this judgment of General Court Martial and then 2 lines quashed?
I not, with respect, there is no necessity of the nullification of the judgment of the court martial or to the criminal division of the High Court. Lord, under Article 139(1) of the Constitution,
Article 139.
139,
Yes.
I think, Clause 1 of the Constitution. You are seated with unlimited jurisdiction, including the jurisdiction to put in effect what the Supreme Court ordered. Namely, that convictions and sentences that were imposed by the General Court Martial on civilians, contrary to the proper interpretation of the Constitution, are null and void if they are being challenged.
Let me also give you another example.
So it is my submission is that this does not require, because you are not now going to try Eron Kiiza.
Yes.
You are simply declaring his right, and it's the civil division dealing with right.
I hear you, Counsel.
Just declaring his right, that whatever was imposed on him, this is challenging it, is a nullity, he should be set free.
Let me give you another. Let me tease out another example, quick one. Honorable Kahonda had an electoral dispute in Mitoma district. He filed an application in Tororo, and my brother, the late judge, took the view that as a High Court judge, we have floating jurisdiction, that you can sit anywhere and handle any matter, because our. So when you took that line, I remembered that decision of our brother judge. He passed on. So is it your case that wherever a judge is, he can entertain any matter regardless of the divisions that we have in this country or the circuits that we have?
Hello, divisions
are administrative conveniences. And you only operate, for example, in Kampala. Not if you are seated in Masaka, you'll be handling land matters, you'll be handling criminal matters, you'll be handling civil matters. I'm not so sure, but I've argued that you should be even handling labor matters in spite of the existence of the industrial court. Because they expect one industrial court in Uganda to handle labor matters in Karamoja, in Kotido, in Kabale. It's not administratively convenient. My lord, we are dealing with the right and the liberty of a person in this country. His liberty cannot be the subject of administrative conveniences. At the earliest opportunity, your lordship seized with unlimited jurisdiction. Is my humble prayer duty bound
I've heard you now.
to give effect to the judgment of the Supreme Court?
I've understood. Now I've got you.
In fact, my lord, there were attempts to file these matters in the criminal division. And on Ekimis, the registrar in the criminal division purported it even dismissed.
Okay, that one is valid.
So really, to toss this.
No, I get
case
you.
from
Do you have
Division 1?
evidence
Yes.
that you filed and the registrar decommissioned the file?
Yes. Yes. It is
Yes,
not
I wish I can have that, because then you can head up this court.
shall supply. Shall supply. My land friend, Mr. C, can say more on that particular matter.
Yes, my lord, regarding that, when we filed the matter in the criminal division, which we are going to supply to court, we even met the head of the division, and he brought to our attention a decision of that court that any matter involving Attorney General should be filed in the civil divisions. And that informed the registrar's attendant decision to decommission.
Yeah, and which now makes it now a little bit different, because had you filed, for example, an application for revision, because the revision you are seeking to formally nullify everything that was done, because and you don't need so many paragraphs. Maybe we shall have a discussion.
I was just putting it on your record. It's miscellaneous cause number 20 of 2025.
Speak to the microphone.
It's Eron Kiiza versus the Attorney General, miscellaneous cause number 20 of 2025.
Yes.
Which was filed in the criminal division.
And the key reason given was that for as long as there is the AG
as a party,
then the criminal division cannot entertain.
Yes, my lord.
Which means if you had not included the AG, probably they would have given you audience. That's what I'm trying to.
Well,
yeah, but you see, my lord, the AG is the representative of the authorities that are holding Mr. Eron Kiiza in prison. You can't really have filed this matter without the Attorney General's involvement.
Yeah, I agree. Okay.
Wouldn't want to come and then they say, but why didn't you serve Attorney General? Why didn't you, who will speak for the prison authorities and so on?
Yeah.
So the matter, my lord, is properly before we.
No, the rest of the arguments are very clear. No, that's not. Mr. Wanziri has really done it. So the rest you are now going to speak good English.
No. I would just like to just mention something.
No, it's okay.
Just copy that.
AG. Okay. The reply. What is your argument? In the file where you reply, just 2 points.
Your Lordship, the facts of the
Go
case,
back on record for our transcriber.
Johnson Atwera, I'm a senior state attorney. The facts of this case is that my brother, Mr. Eron Kiiza, an advocate of High Court and all courts of judicature in Uganda, was accused of contempt of court in the General Court Martial.
Which court is no longer in existence?
Not at all, my lord. It is in existence.
Okay.
The Supreme Court did say that the General Court Martial is a court of law under the Constitution of Uganda.
Now that's the point I wanted.
Yes, it did not abolish it. It reaffirmed its existence, but only limited it to specific cases of offenses relating to military service.
How about the way it was constituted?
It gave, the Supreme Court gave advisory on how best it can be constituted, but it did not give orders.
Okay.
Yes, my lord. So Mr. Kiiza Eron was accused of contempt and was tried and sentenced in accordance to Section 169.
What is the sentence under the law?
That's where I'm coming to, my lord. Under Section 169, 1G, it relates to contempt of an advocate. And when you read it in relation to Section 2129 of UPDF Act, it says it gives an advocate who is charged of contempt before the military court of a maximum sentence of 5 years.
Okay.
The sections
not 1 month.
Not at all. Maximum 5 years. I want to believe that my former professional advisor at LDC is misconstruing it with the application of the law 169 1G and 2129 of the UPDF Act to Section 169 2, which is general in application that gives 30 days. But Kiiza Eron, being an advocate, it puts him under a specific provision of 169G, 1G, and 2129 that gives a maximum sentence of 5 years.
So you are saying actually the court was lenient?
Absolutely. Okay. Actually, the court martial was lenient, considered his.
Do you speak to that in your reply and arguments?
Yes, my lord.
Thank you, sir. Yes.
My lord, I want to refer to Order 3 of the Supreme Court decision number 2 of 2021. Honorable Kabazigo, Attorney General versus Honorable Kabazigo. It said that this judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and
you can
sentences.
Remove the word save and put except.
Except.
Except
where.
Make
it easier. Except where the conviction and sentences are being challenged in courts of law.
So, is it your view that the conviction and sentence of the person in court
were affirmed? Were affirmed by the Supreme Court that they carry legal basis and are effective.
They are effective for as long as they have not been challenged.
Yes.
Now,
and even the challenging, the Supreme Court did not dispose of the challenging It says it did not, it means that where the challenge is ongoing, the trial can continue and be challenged.
So for me, what I'm raising at this point is this decision properly.
This matter arises from a conviction, it arises from a matter which is criminal in nature, and the right forum would have been the criminal division.
So who would have been the respondent if not the AG?
Uganda, the state of Uganda.
Represented by who?
Uganda would have gotten its representative. Uganda has many institutions which are in charge of its defense and prosecution.
So you are saying you are not so sure.
I'm very
It's
sure.
Uganda, but we don't know a particular agency, institution.
Your Lordship, Uganda is alive and it's known.
But this court is also Uganda.
Yes, my Lord. We have, for example, the office of the Director of Public Prosecution.
So that's what I was waiting for.
Yes, my Lord.
So that's the Director of Public Prosecution.
Because
is she
the order,
possession of this file, the subject of the conviction?
my Lord, she doesn't necessarily need to be in possession of this file. As long as a citizen of Uganda is aggrieved and has sued the state of Uganda, the fact that you have sued the state of Uganda, that file would be put to the attention of the office of the Director of Public Prosecution. And unless the applicants choose who should be, I think I feel that in this particular case, he chose a preference of who should be the respondent.
I've got you. So,
my Lord, it is my submission that this application is misconceived. Mr. Eron Kiiza is serving a lawful sentence, which was never set aside by the Supreme Court. He has all the remedies available for him. He can appeal. He can file an application for revision if he's aggrieved. But coming civil, apply for an unconditional release, it's absurd. This is not the right for us.
We started with 2 points in 1 minute. Then we call it.
Yeah, but well, I'll take your points. Then I see whether they cover the.
Because the rest of the information is in your. I've already the very detailed.
Yes, my Lord, I can take your 2 points. Yes.
I want you to make the 2 points.
Oh, you want me to make 2 points?
I thought you wanted to.
Yes, in reply, I think there should be clarity here. My Lord, the matters before you do not constitute a criminal appeal or a criminal revision. If they did, then we would concede that they should be before the criminal division. The matters before you are matters of human rights enforcement, are matters of habeas corpus, which is a non-derogable right of enforcing the right to liberty. They are properly before you, and the proper respondent is the Attorney General. What Eron Kiiza seeks is not to interrogate his sentence, or even the process of the trial. What section was he convicted under? What sentence should have been imposed? Those are not the arguments we are making before you. Our argument is very simple. Eron Kiiza is a civilian. He was convicted, albeit without even a proper trial, actually without a trial, by the General Court Martial. He appealed that conviction to the Court Martial appeal, which is still a court of law. And the Supreme Court has said, and we want the words of the Supreme Court given life, that if you have been sentenced, convicted and sentenced, the nullification of the proceedings through which you were processed in the General Court Martial has a retrospective effect. If he had not appealed, then he would have served his sentence. But as long as he appealed, the nullification of the proceedings acts retrospectively to restore his freedom.
I get it now, because the Supreme Court could have said, the court martial appeals, please expedite the appeals.
Yes.
And they said no, go to, created a bypass to the civilian courts.
Okay. Yes. So it is that simple point. We don't have to labor it. It's a human rights matter. It's a civil matter. It has nothing to do, because you see, revision would mean that you go to the criminal court, civil criminal division, to do exactly what the Supreme Court said. But the Supreme Court has already said this is the wrong court to try you, the civilian. And if they have convicted you and you appealed, get your freedom. My Lord, Counsel Eron Kiiza comes before you as a civil court to enforce his right to liberty. It's our prayer that this court restores his liberty by ordering his immediate and unconditional release. We so pray.
So I think this is sufficient. Monday at 2:30, you'll have a ruling. You don't have to bring Eron unless, yes, sir. Okay. What I normally do, Mr. Eron, I normally share decisions on lawyers, but I will honor your request. So, yeah, okay.
omulamuzi yongeddeyo okuwa ensalawe bbalaza ssaawa 8 era tuba tusuubira okuba nga Eron afuna ensalawo ye oba ateebwa oba ateebwaye waliwo application okusooka beyateekamu n'okusinziira sayidi ya gavumenti ekizudde nti application zino zirimu enagala okufaanagana so ne basaba nti bagiwenge oba bawakanye empoza zange ez'enjawulo so bwe kusalawo nti amateeka ab'enjuyi zombi era okuwa ensalawo ye ensonga omunga tumanyi Kiiza
They must never stand in any matters of activists and defenders of human rights. Yes. Kiiza is on record for hijacking cases like mine. Kiiza is on record for sending a nearly dying Kakwenza to prison. As lawyers, Tumakunga, please resist judges like Kiiza in matters of human rights. Full stop.
Even now, got information. Nancha, she's the husband of the prosecutor. She's the wife of the prosecutor of the ICD court.
Nancha stop persecuting.
Yes.
And other activists.
Not only.
Nancha stop persecuting.
Say no to Nazis judges.
We are tired of.
Activists say no to Nazis judges.
We are tired of.
They know like Kiiza must never appear in any court. Say no to Nazis judges.
No, your husband works in the guy is a prosecutor in the ICD court. Nancha, stop trying civilian, take them as military rules. Stop it, Nancha.
Send us to see this.
Nancha, Manasi. Who? Singiza. And Nanja. Nanja, she's a
So what do you want? Well, today we came to receive the ruling on the various applications that had been filed to seek the freedom of counsel Eron Kiiza. First of all, the judge then first said that today was not the date for the ruling, and he stepped out. When he came back, Mr. Eron Kiiza had been brought by the prison authorities. So eventually we ended up before the judge. The judge then asked whether we had complied with the service and filing of affidavits and written submissions, which on our part we confirmed. The state attorney claimed that he had not received some of the submissions. But then he said that in any event, the various applications all seek the same remedy, and apparently that whatever he had filed is enough to dispose of all the applications. The judge then asked us to summarize the gist of our argument, which we did. It's a very simple argument that all convictions and sentences by General Court Martial in respect of civilians like Eron Kiiza, which were challenged and in the case of Kiiza by an appeal, were nullified by the Supreme Court. So we asked the judge to restore Eron Kiiza's freedom by ordering for his immediate and unconditional release. The judge and the state attorney at some point were of the view that this matter should go to the criminal division of the High Court. And our reply was simple. The matter we had brought before the judge was not a criminal appeal. It was not a criminal revision. It was not to interrogate the sections under which Eron Kiiza had been convicted and sentenced, but rather a matter to enforce the right of Eron Kiiza to his freedom, a freedom that the Supreme Court had, in its ruling in the Bazirukuka case, declared. So the judge has said Monday, 2 o'clock, to give his ruling. We hope that this time round it will be ready. It's unfortunate that this straightforward matter is taking us another one more week.
And so the statement maintains Council Eron Kiiza is serving a lawful sentence in prison, and that any matters that were against him stand as is today.
No, there's no lawful sentence. Once the sentence was appealed, the judgment of the Supreme Court had a retrospective effect of nullifying that sentence. The word retrospective is a simple English word, which we believe that everybody understands. Something retrospective is that it works backwards. Okay? So, the effect of the judgment of the Supreme Court was to work backwards and nullify the conviction and sentence of Eron Kiiza. And the simple thing we ask the judge is, can you make that order to release a lawyer who is in effect illegal detention now? Ffenna tubadde tulowooza nti omulamuzi Justice olwaleero anaawaayo ekiragiro ekiyimbula Council Eron Kiiza, naye tekisobose. Omulamuzi ne Setatone balabise ng'empapula ezimu ze twateeka ku kooti tebanaziyitamu bulungi. Omulamuzi n'atusaba tumunnyonnyole mu bufunze nsonga ki gye tuleeta mu maaso ge. Ne tumunnyonnyola nti mu musango gwa Kabazikuka, Supreme Court yasalawo nti omuntu yenna atali muserikale eyasingizibwa emisango n'asalirwa naye n'ajulira nti emisango egyo kooti yagimenyawo, n'olwekyo teri nsonga mu mateeka lwaki Eron Kiiza akyali ekitale mu kkomera, era ne tumusaba amuyimbule. Omulamuzi atuwadde olw'ebbalaza olujja 8:00 okuwa ensala ye. Tusuubira nti ku olwo Council Eron Kiiza anaddizibwa eddembe lye. Ekyo n'okibuuza mulamuzi, kubanga ekimu kyabadde alowooza nti si yandibadde mu bitambo gy'omusango guno nti gwandigenze mu criminal division, naye tumumuwabudde nti Eron Kiiza tazze kujulira, tazze kwemulugunya kawaayiro ki court martial ke yakozesa okumusalira. Azze kutegeeza kooti nti Supreme Court yasazaamu ebyo byonna ebyakolebwa n'olwekyo ab'ekkomera tebalina tteeka mwe bamukuumidde, so tekyetaagisa ate kumutwala mu criminal division kubanga tagenda kwewozaako, takyalina kyakwewozaako. So tusuubira nti omulamuzi olwaleero akitegedde bulungi, kasuubire nti anaatuwa ensala gye tusuubira, tunaalabagana ku Mande.
Kale ensonga nga muziwulidde ndowooza sijja kuziddamu kuzitemaatema badde muzigoberera bulungi ddala. Ebintu bitambudde olunaku lwaleero era tusobole okuma wano ku Mande essaawa 8 ez'akawungeezi. Aba oba oli awo tunafuna ensalawo oba ate wanaabaawo ensonga y'okwekwasa okusaba okuyimbulwa kwa mukulu oba kanso Eron Kiiza owa Kiiza advocacy ng'ono munnamateeka wa abasibe abalala Kiiza Besigye ne Haji Obed Mutale. Kale muzikirize mberekereze naye nga mbeebaza kubanga mubadde naffe okuva tutandikidde okutuusa wano. Nze mukose Arnold Anthony nga mbadde butereevu ku Alternative Uganda Digital TV era nga tubaagala nnyo, mwebale ddala, temujjanga okwo. Mubeere bulungi, Mukama Katonda batukuumire, mweraba.